हेलो दोस्तों, ऑनलाइन स्टेनोमेंटर में आपका स्वागत है। मैं आज आपको लीगल डिक्टेशन प्रोवाइड करवाने चाह रहा हूँ, जिसकी स्पीड होगी अराउंड 102 वर्ड पर मिनट एंड वर्ड्स होंगे अराउंड 680। सो बी रेडी फॉर इट। Learned counsel for the applicant of review application submitted that there is a mandatory provision of law that for deciding the appeal under section 100 CPC stop. It is a condition precedent to exercise power of High Court to formulate superficial question of law and pass order accordingly, and second appeal cannot be decided merely on the equitable ground stop. He further submitted that in the present matter no specific question of law was framed, no lower court record was summoned for consideration, and at the time of admission this court had allowed the appeal after hearing the arguments of counsel for the parties stop. According to him, this was apparently an illegal procedure adopted by this court at the time of his passing impugned judgment dated 13 May 2016, which is error apparent on the face of record stop. His submission was that although argument on points of judgment were placed by counsels for both the parties, but instead of framing of substantial question of law before passing the judgment, this court had erroneously passed the judgment of allowing the appeal. Therefore, said judgment should be set aside and matter should be reheard and redecided after framing substantial question of law stop para. These submissions were opposed by the learned counsel for the opposite party, who submitted that in this matter at the time of hearing of second appeal all the questions on facts and law, including all the possible substantial question of law, were appreciated, and then after due consideration on every point's judgment in question was passed stop. He contended that every fact in this matter was proved and admitted, and at the time of hearing of second appeal, concurrent finding of fact was there, which had earlier been given by trial court and was confirmed by first appellate court, and said finding of fact was being supported by respondent side stop. The judgment in second appeal was on the point of pure question of law for which admitted facts were available before this court, which had considered them, discussed them, and judgment in question was passed after appreciating and deciding those points stop. He further submitted that after considering those points in said judgment, Supreme Court had affirmed the judgment, and it had specifically been observed that for said judgment of second appeal there is no reason to entertain SLP stop. His further alternative argument was that every probable substantial question of law was raised through argument of second appeal that was mentioned specifically by this court and was decided on merits without any factual or legal error stop. In such matter, there is no legal propriety to rehear the matter on technical ground for passing same judgment which is not erroneous on merits stop. So, this review application should be rejected as it is found that this judgment was passed after considering the admitted facts and admitted legal position stop. It is a fact that ordinary procedure is that before allowing of any appeal, generally substantial question of law should be framed at the time of admission of appeal stop para. But in present matter, at the time of hearing of second appeal, this court had not found any reason to summon original record because of relevant records and their copies were found available with the memorandum of second appeal and relevant facts were admitted stop. Parties were afforded opportunity of hearing and the impugned order was passed on merits after appreciating the arguments of the parties stop. The judgment in question was not passed with erroneous knowledge of law or procedure stop. After hearing, this court had found that relevant points relating to the matter in appeal can be decided immediately on the basis of material available before this court in view of relevant legal provisions stop. Accordingly, this court had passed the said judgment in which detailed discussion of contentions of both the parties was made and the matter was decided stop. Although no formal substantial question of law was framed by this court, but the question of or point of law relating to matter was properly considered, appreciated, and discussed by this court at the time of passing said judgment dated 13 May 2016 on its merits stop.